the former Chief Justice, Madam Torkornoo, and the Abeto Nyina say the President of the Republic, constitutional eshano say onjina so na onfa and take a decision. President Nonkwa Onisa to me say and obi edibone and I say waye adie etie ejuma oya obetuma yinedi President Onisa to me no so obetuma pam Chief Justice. Na constitution na ma to me it is our constitution na ojina so edidi sa adwuma no. Now and the okan statement a free Jubilee House by and our Flagstaff House and I say the President John Dramani Mahama has, in accordance with Article 1469 of the 1992 Constitution, removed the Chief Justice, Her Ladyship, Justice Gertrude Araba Esaba Saki Torkornoo, from office with immediate effect.
The removal of the Ghana's Chief Justice Gertrude Araba Esaba Saki Torkornoo in 2025 marks a historic and a controversial moment in the country's judicial history. Here is a full breakdown of what happened, why it happened, and what comes next. Chief Justice Araba Esaba Saki Torkornoo, appointed in 2023. She became the third female Chief Justice in Ghana's history. But by 2025, her legacy was under siege. On March 17th, 2025, a private citizen, Daniel Ofori, submitted a 15-page petition to President John Dramani Mahama of allegations against the Chief Justice of misappropriation of public funds, administrative misconduct, and tampering with court records. Two more petitions followed afterwards. The Council of State reviewed them and a prima facie case was established, and the President acted accordingly. On April 22nd, 2025, President Mahama suspended the Chief Justice, and this was the beginning of a battle that will not end well for the Chief Justice for her 21 years in service to the nation. A 5-member committee was formed under Article 1466 of the Constitution. The hearing began. Witnesses included former Chief Justice, legal luminaries, and even the Ghana Bar Association. After months, the committee were wrapping up their investigations and their court proceedings. On September 1st, 2025, the committee concluded their hearing and presented their report to the President in the Jubilee House.
Ladies and gentlemen, Mr. President, in March this year, you received 3 petitions pursuant to Article 146 of the Constitution 1992 for the removal of Chief Justice Gertrude Araba Saki Torkornoo, and the public was made aware of this fact. Subsequent processes dictated by the Constitution and the decisions of our Supreme Court were gone through, culminating in the establishment of our committee under Article 146, Clause 6 of the Constitution. The nation was further duly informed, and when we commenced our work on the 15th of May 2025, the Minister of State for Government Communications was briefed and notified the public about it. There has been considerable interest in our work, shown through comments and opinions by Ghanaians and international observers as well. However, the committee restrained itself all along from reacting, even when blatant false statements were made about members of the committee and our work. To the committee, our mandate and remit is set out under Article 146, Clauses 7 and 8 of the Constitution. It's clear, and it is to inquire into the petitions in camera. Here, the person against whom the petitions have been brought in her defense by herself or by her lawyer or other expert of her case, and then make a recommendation to you, Mr. President. As I have said above, 3 petitions were referred to us. And though all 3 petitions seek the same relief, each petition is distinct and would succeed or fail on its individual strengths or weaknesses. Mr. President, without disclosing the substance of the proceedings, and since in-camera proceedings is not the same as in secret, we can state that in respect of the first petition, we received evidence by Mr. Daniel Ofori, the first petitioner drew 13 witnesses. Similarly, the Chief Justice in her defense called 12 witnesses, including expert witnesses, as she is entitled to do under the Constitution. The Chief Justice testified personally and was cross-examined. The committee received about 10,000 pages of documentary evidence from both sides. There were 4 lawyers that represented the first petitioner, Daniel Ofori, and 4 lawyers represented the Chief Justice. Mr. President, after critical and dispassionate examination and assessment of all the evidence, including the expert evidence, against the provisions of the Constitution and the relevant laws, we have, without fear or favor, arrived at a recommendation on the first petition. The recommendation is contained in the envelope which I now give to you.
After some hours, the president announced the Chief Justice had engaged in avoidable and reckless dissipation of public funds. The president, bound by Article 1469, removed her from office, and for the first time in the history of Ghana, the law is being applied irrespective of position and influence. Should this end here? Is this government cleaning the system? Is this government making Ghana great again? Or is this a political vendetta? I personally recommend John Dramani Mahama for this bold move and request from him to do same to all those who are against the development of the nation. Based on the action of some corrupt politicians and some judges in Ghana, our country, many young Ghanaians are crying every day. As a result of misappropriation of the poor taxpayers' funds, many Ghanaians are dying of road accidents and dying in our hospitals. After the president's announcement and the removal of the Chief Justice, Kevin Taylor, as we all know, came on his platform, and this is what he has to say about the Chief Justice. Let's go watch that video.
Under Article 1469, the president is required to act in accordance with the committee's recommendation. In the committee, na Ghana Constitution, President Mahama say, "Onto one among every say committee na actually say, Maameno, Sebio, the Jumedia no Odino, 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 and Fakwemu, Sebio, we boom raso, Sebio, ni Chief Justice no Odino, and Nisia Manatinaho. Into constitutional President, Sir President, so Endim Rano, so now Fanensa, and Yade, and Shakratase. Into the law is the law. Into Emrano, so okay, Ghana Constitution na se Sebio. On pese obi begina baby atu mfutregu ani a okay constitution say neka constitutional enamede atoso no chapter 11 the judiciary okay 146 article 9 say na kire removal of chief justice of superior courts and chairman of regional tribunals. Now oko article 9 na ene wa ase no say na constitution eka or say the president shall in each case act in accordance with the recommendation of the committee. Inti Bronika Bibi says shall eyense. Inti committee need the recommendation the president no na on to me bibia constitutional esseno. And it's a constitution is say shall. Constitutional anchor say might, should think or might, or the president one man or any other room for him to even take another decision. The constitutional president say the president shall a command. The constitution instructed the president to do that. So president in fairly say recommendation na committee need the brand no. So when this wa sa constitution now so be to be two president no.